You guys will get started in just a few minutes. We're waiting for the sponsor of the first. Welcome to the Children and Families Committee. And before we start, I'm going to ask Senator Burns, what's your mic number? 13. To open us up with a devotion. Thank you.
Welcome to the Senate Family and Children Committee. If you would, please join me in prayer. Father God, we're grateful. We're blessed and humbled by the privilege of service. We thank you for the matters of the day. We ask that you help us to make Georgia a better place for families, a better place for children. Give us your wisdom and your guidance. In Christ's name I pray. Amen.
Okay, we have two bills this afternoon. The first one is House Bill 509, Chairman Ballinger. The second one is House Bill 144 by Representative Lewis Ward, and that one's a hearing only. So Chairman Ballinger, if you would step up to the witness table, if you've caught your breath, and tell us about 509.
Make sure I have my glasses so I can actually read the bill. It's not as helpful. Okay, I find it easier to address really the issue or the problem that this bill addresses rather than, kind of trying to just get into the language, because the language as it is kind of taken out of context really doesn't say much. Right now, if you're in a domestic violence situation, you're in your home, your ex comes storming through the door, breaks the door down, comes in, knocks you around, leaves, is guilty of 2 misdemeanors, battery and criminal trespass. So those are 2 misdemeanors. However, if he steals a toaster or a knick-knack of yours on the mantle or anything, then he is guilty of a felony here in the state of Georgia. That's actually burglary here in the state. So, I think our domestic violence victims are worth more than that. I think they are deserving of respect, and certainly more than that of a toaster. So what this bill would do would make, if somebody breaks down a door, commits an act of family violence, then they would be guilty of a felony. And that's what the bill does. Happy to answer questions.
Questions from the committee? Mallon?
Thank you, Madam Chair. To Legislative Council, want to clarify residency because as I was addressing this issue with Legislative Council, residency on the civil side and what's in criminal statute may not be on the same sheet of music or in this bill. And I'd like to ask Legislative Council to weigh in on that conversation to provide clarity on that, because if I live at a place, the police can't make me leave. If I say that's my residency and I have a key, you have to go and evict me. So then how can I be charged in the criminal statute if I have to be evicted first? I just want to make sure we get that clarified.
Ms. Alexander?
Yes, and I appreciate that. I think that in terms of how this is particularly written in the criminal sense, we're looking at without authority. Without authority is defined in 16(1)(3), paragraph 18, meaning that without legal right or privilege or without permission of a person that would be legally entitled to withhold that right. So that's kind of the context that we're looking at with that. But you're right, there are distinctions between residency, both in the civil and the criminal sense.
Okay, we have a couple other questions. Senator Estevez, I think you want to go ahead. Senator Jackson.
Thank you, Madam Chair. And Madam Chair, thank you for bringing this. Can you help us? Is there somewhere in the code section define a definition for romantic partners? I know I've worked a lot in this area of stalking and family violence. I know there's dating violence, but I don't know about romantic partner, if that's defined.
It's not defined.
And so if this were to become law, how would someone know how would this be charged for a romantic partner if it's not defined?
It would be something current or former romantic partners. Obviously, that would be just one of the things that the DA's office would have to prove, or the prosecuting attorney would have to prove, that there was some sort of romantic relationships, the same as they would in any domestic violence situation. You know, a lot of domestic violence occurs between dating partners, occurs between people who are not necessarily married. So it's not like you can hold up the marriage certificate and say, aha, domestic violence. It would be much the same way that they have to prove that in almost, I wouldn't say almost all, but in many of the domestic violence situations where they do have to prove some sort of close relationship between the two.
May I go further? Just-
Yeah, I think Legislative Council had a comment also.
Oh, no, I was just, that is correct. Romantic partner is not defined in code, but dating relationship is, and that's 1913A1.
Right, and so that's going to be a follow-up question. Is there a reason why you chose to use the language of romantic partner versus dating relationship?
Well, romantic partner is easier to prove than dating partner. If you go into dating, you're actually talking about the physical act of a date. So, well, they went for coffee. Is that a date? I don't know. They were seen holding hands at the coffee shop. Obviously, that was a romantic outing. It's one of those things where if you were to parse it out, it would just be easier for prosecutors to prove. So that's why we chose that language, as opposed to, and having somebody who works really hard on the whole, I was very involved in the domestic violence temporary protective order issue. We kind of went round and around and around and around and around with some of those definitions, and romantic partners were deemed kind of the easiest one that we could come up with.
Okay, and then just if you don't mind, so your understanding is that this bill makes the act of family violence a felony? No. I misunderstood. Could you please? I misunderstood your explanation of your bill. Then, would you mind repeating that?
The act of breaking down her door, knocking her around, and leaving, violating her home, making her feel less safe, hitting her, physically striking her, without impunity towards that closed door, I think should be a felony. And it's the combination of those factors that should be a felony. This doesn't get in the way of family violence battery. It doesn't get in the way of family violence aggravated battery, including strangulation. I added that. It doesn't get in the way of a lot of other family violence. I don't want to get in the way of those other family violence charges, but I did think the totality of these circumstances, breaking down the door, ruining her peace, knocking her around, committing acts of family violence, and then leaving, I thought that the totality of those circumstances warranted a felony.
So, one last thing, if I might add, I want to thank you, first of all, for your work and dedication to this area of the law. We have a lot of synergy around that. I think my concern with the bill is that, from my reading of it, the act of breaking in is an act of family violence. It doesn't actually, this bill does not say the act of breaking in and knocking her around, hurting her, is therefore a felony, family violence. It just says the act of breaking in, the act of burglary in and of itself becomes family violence.
Burglary in and of itself, you have to commit a theft therein, or you have to have the intent to commit a theft therein. So therefore, you can't just break in. That's criminal trespass. You have to have, there has to be an additional act that's actually committed. In the offense of burglary, it's stealing. So with this, it's an act of family violence.
Whether or not you hurt the person or not, whether or not you hit them or not, it's just the act itself will become family violence.
You could, if you were to commit, say, a simple assault or a simple battery, then you may not necessarily strike that person, but you're still committing an act of family violence.
Okay, other questions from the committee? We do have one person signed up to testify. Crewman Dillard, if you want to come up, and Chairman Ballinger, stand by. Go right ahead.
Good afternoon. Thank you so much, Madam Chair and members of the committee. My name is Karima Dillard, and I'm the Director of Policy for the Georgia Coalition Against Domestic Violence. I was here recently with Senator Jackson. We were working on the address confidentiality bill, which I'm really pleased to know passed the Senate. Thanks to you all. So I want to first start by acknowledging the many years of dedicated service Chairman Ballinger has given to victims of violence, particularly domestic violence. I don't know if many of you know, Chairman Ballinger started out as a domestic violence advocate, shelter advocate, and she brings with her many years of experience and expertise, and has used her platform to really support the safety and justice of victims. We met with Representative Ballinger to talk about this bill, and many of you may be surprised to know that the 1994 crime bill that was passed in Congress that was designed to do many things, among them expand protections for victims of domestic violence, enhance penalties for abusive partners, and we were really hopeful that it would go a very long way in curtailing, addressing, decreasing the incidences of domestic violence, and unfortunately, it really hasn't. And then half of domestic violence victims don't actually involve law enforcement at all. They don't seek the criminal legal system to address injustices. However, for those who do, we want to make sure that the law is clearly defined and that the prosecutors and defense attorneys know exactly what to do and how to engage these cases. I spoke with some frontline advocates about the bill, and they just had a few questions about how the bill would be implemented. And I'm not a legal mind. I leave that up to those of you who are. But what I can say as an advocate is that these relationships can get really messy sometimes, and identifying, for example, who the predominant aggressor is in some cases can be really difficult. Identifying what the charges are can be really difficult for law enforcement and for prosecutors. One of our advocates gave the example with the definition of romantic partner, and I appreciate Chairman Ballinger explaining the intent behind the use of the language romantic partner. But let's say me and my former partner, not spouse, dated 5 years ago. We connected over Facebook. We decided to meet up again. We're talking. Things get a little bit tense. Argument ensues. I ask them to leave, and they see my cell phone and they throw it against the door. I've asked them to leave, they didn't leave, so that's criminal trespassing technically, right? They've thrown my new platinum iPhone against the door, so that's more than $500, so that's criminal damage to property. So both of those together, it sounds like from the bill, would be a felony. But in the reading of the bill, it feels like there's a word missing, a word or two missing that just clarifies that those things have to happen in conjunction, and that they're not in and of themselves a felony. And I just want to kind of go on the record saying that the span of years that the person would have to spend incarcerated, I think minimum 1, maximum 20. If someone is serving a year for damaging a cell phone, when they come out, they're not going to take their frustration out on the criminal legal system. They're going to take their frustration out on the survivor. And the examples that Chairman Ballinger uses, I agree. And I have to say in the testimony that she gave in the hearing last year in Juvie Justice, she said something that I really agree with, that the underlying emotional aspect of the offense is that not only can I break your door down and destroy your TV, or in my situation, cell phone, but I can break and destroy you, and that makes it especially terrifying. And I agree, like, something should be done for those really egregious acts of family violence. And we just have to be really careful that we don't create loopholes in the language to make it easier for people to not be held accountable when a survivor really does want to use the criminal legal system to address the violence. So what I'd like to just ask is that some of the language be tightened up. It would be great if some of the reference codes could be similar to the family violence statute and the dating violence TPO statute. One defines what the actual charges are, what the offenses are under family violence, and the other describes what the relationship is under dating violence. Just to protect everybody and make sure that we're not inadvertently harming victims. Are there any questions?
Yeah, we do have one question for you, and I had you down as testifying in favor on this sheet.
I know it sounds a little confusing. I'm in favor of supporting victims. I'm in favor of language that's clear that supports victims. I'm not opposing the bill, just wanting it to be tightened up just a little bit.
Okay, Senator Robertson.
Thank you. And I was a little confused too, because I actually read through the bill, and I think Chair Ballinger has done an exceptional job of making some minor adjustments in the right way. The hypothetical that you gave, you invite the individual in, y'all are trying to reconnect. The individual gets upset about something, they take your phone and throw it against the wall. I know when the individual is invited into the home, and Chair Ballinger covered that, there has to be an intent coming into the home, and burglary does not require the kicking down of a door. A burglar can reach and turn the doorknob and walk right into the house. I think what the bill does is when the individual comes to the property with the intent, and where we find this on a lot of TPOs and other things, and like you're talking about, the individual, 99.999% of the time it's a male, goes to the house, they're going there with the intent to commit domestic violence against the individual that lives there. That domestic violence does not necessarily mean touching them, because we know there are assault charges that you can get in the state of Georgia without ever putting your hands on anybody, screaming in their face, doing several other things. Yeah. And even to your case, even if you pulled the phone out of someone's hand that was trying to make a 911 call, that could be an interference with a 911 call, but it necessarily, you would have to show that the intent when they got there, when they came into the house, was to do that. And I think the language in the bill is extremely clear on that because of the intent to come there. I think what makes this bill so important is the fact that a lot of our domestic violence victims are targeted victims. These aren't just things that occur in a vacuum inside of the house based on an argument that happens once they're inside the house. But these are individuals going there to that property to commit domestic violence out of anger. And so I think that's where the difference maybe in your interpretation is, because I think what's in the bill is I think it's tight. It's very clear based on the limited amount of language you put in there. I think the other side, and I agree with you, there are other instances where somebody snatches a phone away, throws it. And if they are domestic violence charges, there is an enhancement. Because there's simple battery in Georgia, and then there's simple battery DV. Those are two entirely different things. So I think that's covered in there, and I think this is much more limited to the individual showing up at the home, the apartment, the abode, or wherever, and going in there with the intent to cause that. But I do appreciate your testimony.
Well, and I appreciate your comment, Senator Robertson. I just want to clarify that family violence, it requires a pattern and a history. It's not usually just one incident. It's not one event. And again, when we're talking about essentially forcible felonies, I think that we can all envision somebody coming to your house, kicking the door down, smashing your television, throwing around expletives. That's absolutely terrifying. What I'm talking about are those instances where it's not as obvious, those less egregious incidences that could escalate, that we want to make sure we're not having people fall through the cracks. So not those obvious forcible felonies, those obvious egregious acts of family violence, but those less egregious acts that are a little bit more complicated and less clear. less clearly defined.
Okay, you have one more question. Senator Mallon?
Thank you, Madam Chair. I just want to clarify kind of what we've discussed with coming in and knocking your cell phone out of your hand. At that point, the individual will be guilty of criminal trespass, which would be 16-7-21, which would interfere with your right to use your phone by hitting it out of your hand and interfering with your right to call 911. And when I look at the criminal trespass statute, it is a misdemeanor. And what I see in this bill is the intent to upgrade that domestic violence action to a felony. But in this code section 16-7-1, it's not tying everything together the way I'm looking at it. And so I would see that under 16-7-21 as adding an enhancement to a felony for criminal trespass if you did these things, because then it would be in line with the additional code section. Because right now, criminal trespass doesn't mention anything about domestic violence. Which would be a stronger place in my opinion.
Trying to see the difference between the first two and second.
Did you have a follow-up? You done? Okay. Okay,
Are there any other?
we don't have any other questions for you. Chairman Ballinger, you want to come back up? And would you like to close?
No, I think for a very easy two-sentence bill, I think we've exhausted it. I'm happy to answer any questions.
Any other questions from the committee? Seeing none. Oh, wait. Do you have another question?
I have a motion.
You have a motion? Okay.
Yes, Madam Chair, I'd like to make a motion to table.
Second.
We need to add. Can we have discussion? Sure. Madam Chair? Can we have discussion? It takes precedent over a motion
Okay, so we're going to vote on the motion to table. We've got a motion and a second.
discussion?
Actually, I got a motion to suspend the rules of the committee.
I'm sorry, you have a motion to,
If I make a motion to suspend the rules of the committee, do you want us to?
Just vote the motion tabled out.
Oh, yeah.
okay, so we're going to vote on the motion to table. So, any discussion on that?
Madam Chair? Yes, sir. Thank you, Madam Chair. To the Rules Chairman, having listened to the testimony from someone who is arguably one of the subject matter experts that comes to this Capitol around domestic violence, she raised a number of issues about the lack of clarity that is in this bill. I've also raised concerns about what exactly this bill is doing. I'm deeply concerned about the use of the language romantic partner and its lack of definition. I think that this opens us up to, because it's not defined, you get to make it up. And the one person that you might have had some time with could say, oh, you're in my house and you're my romantic partner now, and have you accused of not just burglary but family violence. I just think that the bill is not, it's not exactly where it needs to be. I understand the author's aims. And please hear me that I have great, deep respect for the author and the work that she's done in this field. I think it has been extremely important, and I've been proud to work to continue to amplify that. But this bill and its current setup is not in the place where I feel ready to move on it.
Senator Robertson.
Yeah. I guess I always get perplexed by this, that we have really complicated pieces of legislation that move throughout this body, and as little effort is put into vetting some of them. It's shocking at times. And then when we have something that is so simple, we complicate it. I've heard people talk about criminal trespass and everything else. what I understand this legislation to do, and the chairwoman has never had a problem with correcting me, and I know she will if I'm wrong, but all we're addressing is burglary. And in the state of Georgia, as we discuss, someone could come into my house while I'm not there, and as long as their intent is not to steal anything or commit any other felony, they have done nothing more than criminal trespass. Now, if they come into my house, door open, walk in, and they come there with the intent to steal something, to assault me or anything else, then it's a different charge. All we're doing here is adding that if someone comes to your house and the felony that they intend to commit is a crime of domestic violence and not a crime of theft, then that just becomes the catalyst to take it to the burglary charge. That's all it does. And I mean, it's really simple. We have women in this state that are prisoners in their own home, afraid of ex-boyfriends, ex-husbands, and others coming there and assaulting them. And believe me, these domestic violent perpetrators understand the law, and they know the difference between domestic violence and criminal trespass and burglary. And you handle enough of these and you realize that they're in the system and they know what's going on. I think this is a very, very clear piece of legislation, and I, as much respect as I have for my colleague from Public Safety, I absolutely oppose the tabling of this bill. This bill needs to pass out and move along through the process.
Thank you, Madam Chair. I think I want to clarify the posture here. I want to support the bill as well. And I want to support it by making sure we can clarify the language, because if I have a key to the house and I'm a current partner, then I can't be guilty of breaking into some place that I have a key to. And when law enforcement shows up and I can prove that I have a key and I have items in this home, then they're going to, the difference in the criminal statute and the civil exists, because I haven't been evicted here. This is technically my residence, my home. So I want to make sure we can clarify that. Now, we had legislative counsel come out and talk about that. And to quote the majority leader said earlier this week that when we come to Senate committees, we should perfect House legislation, is what the majority leader said. And so that's what I'm trying to do here today, is to perfect this legislation, because I want it to pass and I want a motion to pass. But I want to make sure we don't create any additional loopholes in the statute. And legislative counsel has given us some language and things that we could clarify in the code and making sure that it is ready to go, because I don't want it to be a legal loophole that someone can challenge and get out of it because somebody may be unclear. And with that, Madam Chair, I'd yield back.
Senator Bress.
Thank you, Madam Chair. To my good friend down there from the second, it's hard to, when we vet bills and we're going to quote unquote perfect bills, we do that with amendments. We don't do it by tabling. And so once this bill goes on the table, I don't see this committee working on it. Now, I know obviously we could work on it offline, but I guess my question, if you'll indulge me, Madam Chair, I'd love to ask a question to the author. Did the subject matter expert that came up, did she come and testify against it and have these concerns when it came through the House?
No, there were no concerns expressed. Actually, I was the one that brought it to their attention. And, came and met with them. They've offered me no language, no suggestions, no proposed amendments, anything like that, other than kind of an amorphous, we wish it were tighter, we wish it were better. Or I will say that the language, I did partner, as somebody who has worked with prosecuting attorneys for years, I did vet this through both criminal defense lawyers and prosecuting attorneys who both agree that this is the best language.
And so, this bill has been through the House process. It went to the floor and passed 163 to 4. Now, one of those 4 votes no on everything. So really, it was 163 to 3 in my book. So I don't see how tabling is gonna do us any good. So I'll be voting against tabling.
Okay, so we're back to the motion to table. Unless there's any further discussion, all in favor of the motion to table, raise your hand. 1, 2, 3, 4. Okay, all opposed, raise your hand. 1, 2, 3, 4, 5. Okay, the motion to table fails. Okay, and Senator Roberts,
Motion do pass.
second, Senator Brass. Okay, further discussion? Okay, all in favor of the motion do pass, and then we're talking about LC 480882S. If you're in favor of the do pass motion, raise your hand. Okay, that's 5. And opposed, raise your hand. Okay, 4. Your bill passes. Thank
Okay,
you.
all right. Thank you, ladies and gentlemen. Appreciate it. I know, I don't know. Where can I find it?
Okay, we have one other bill, and this is going to be for a hearing only today. We have a late substitute that came in that the committee just saw for the first time when we started the meeting. So Representative Lewis Ward, do you want to come up and present your bill? And particularly if you could highlight what you've changed in the substitute, because nobody else has seen the substitute.
Thank you, Madam Chair, for hearing this bill. I'm not sure where the confusion came in, because when we requested the bill hearing, it was for LC 1136S, which is the bill that you have before you. So I'm not sure where the confusion came in at.
At this point, let's go through the bill.
So thank you so much. This is my second time presenting this bill at the committee. And when we were here the last time, the suggestion was to go back and work over the summer and come back with some language that may be different. And so we did that. We also heard what the opposition had to say. And we worked with some probate judges over the summer. And the change that we made was basically they felt that they were being limited, and those limits have been removed. On line 22, it reads, such violation has occurred, the court, it used to say shall. The word shall has been changed to may, and the fine was up to $1,000, and now it's been increased to $1,500, and those suggestions were made through our conversations over the summer. So as it stands now, it does not limit any restrictions that the probate judges have. It also gives them options. So I'm here, I'm ready to take any questions.
Questions from the committee? Senator Jackson.
Thank you, Madam Chair. Since we have just a few minutes, it would be helpful. I know we've heard this bill before, but could you just remind us of what your aims are, what your goal is, as it relates to this bill, and instead of just telling us about the changes, but just remind us again of a broad overview of why we're here.
So we're here because a constituent came to me about 1.5 years ago, and she had a brother who was a ward under his wife, and his wife was a guardian, and she was not allowed to communicate with her brother. He eventually passed away, and she thought that the current code should really spell out how and the ways that the ward could communicate if they chose to. And so that's what this bill does. It spells out ways that a ward who's under the guardianship can communicate if they choose to, and some penalties. This bill was vetted several times through the House committee, and they thought that it should have more teeth, and that's where the fines and penalties come in at.
Yeah, so I have one question for you before we get into testimony. Do you feel that this limits judges' discretion in any way?
It does not. By changing the words from shall to may, it removes any restrictions. It gives them the option.
Other questions from the committee?
Ma'am, I'm reading through your legislation. I do remember it, and I think it's a necessary piece of legislation. My concern is if you look on line 23, after the period, it says, after 2 such violations have been reported and subjected to the ruling by the court may impose temporary suspension of the guardianship and appoint another guardian until such violations are resolved. Does the court not already have that ability?
It's possible that they do have that ability. So it may not do anything, it just really spells it out,
Yes, ma'am.
but it still gives them the option.
Yes, ma'am. Thank you.
Any other questions from the committee? Okay.
I just wanted to the author, I've got a pretty good relationship with a lot of the probate judges in my district, and they rarely come out in opposition to anything. And I just want to let you know that I have had some conversations with them, and they are opposed to the bill right now. And I don't know if you're aware of that or not. I think it's a good thing we're not taking a vote, because if we were to take a vote today, I would have to oppose that. But would like to talk to you maybe offline to see if we can get to where the judges feel comfortable and get in a position where I could support this. I just wanted to invite you to come talk to me and work with me. Not saying that my vote will carry the weight of the committee, but I would like to help you if I can.
Absolutely, and thank you for that. And we believe the testimony in opposition was because the previous bill restricted them. It used the word shall, which looked like it was, sounded like it was a directive. By removing the word shall to may, it opens up the door to give them the option.
So I think where the confusion may have come in about the substitute is that we don't have the 01 and 02 copies, which is normally what we'd need to distribute to the committee ahead of time. With that, we've got one person signed up to testify, Judge Wood. Want to come on up and stand by, Representative? Thank you for being with us.
Thank you. Madam Chair, thank you, and members of the committee, thank you for letting me be here. I've not seen the substitute bill yet, so I mean, I think I can.
Would you introduce yourself also and where you're from?
Absolutely, sure. I apologize. My name is Keith Wood. I'm the probate judge in Cherokee County. I was here last year on this legislation. At that time, the probate council had opposed the bill based upon obviously concerns that as a probate judge, what you don't want is you don't want to be restricted to some remedy. You want to be able to do what you think is necessary to address an issue. So to the extent that the language is now goes from a shall to a may, it brings to my mind is if we now have legislation that says you may do these things, why do you have the legislation? Because any remedy that's in here I already have. If I have a guardian who is violating their fiduciary duty, the language of the guardianship code gives me all kind of stuff I can do. I can fine them or assess some penalty against them. I can remove them. I can give them an admonishment if I think that that's appropriate. There's any number of things that a court is able to do in those situations. So to the extent that we now go from shall to may, what we're essentially doing is creating something that we already can do. Why do we need additional language to say, oh, by the way, you can do these things that you already have the authority to do, but if you're going to do them, here's these numbers. Those numbers I could already come up with, and it's going to vary on a case-by-case basis. I'm not really crazy about the idea of fines to begin with, because when you start getting into terms fines, it's like, who does that fine go to? Does that go to the county? Does it go to the party? Does it go to, I don't know. But to me, again, it's not that I don't think that this is brought with the idea of trying to assist people that are wards. It's just, to me, it doesn't really address that, because we already have the authority to do these things. And to that extent, it's just not. Now that it's a may, it becomes even more unnecessary because I can already do those things. As far as, and I'll just mention this, but the additional language as far as how someone communicates, if I was going to add language like that, it would not be so specific. It would be communicate in any manner. Because when you say communicate through visitation, telephone calls, email, personal mail, that's limiting language. You don't want limiting language. You want broad language because communication could be any number of things, not just those. So I think that's all I have on that.
Okay, I think you've got a few questions. A
Okay.
few questions. Senator Robertson?
Thank you, Judge Wood. I appreciate you coming in and helping us out today. Judge, when, and I become, and look, I understand the bill means something to the representatives because she names it after a constituent who has passed away, and I appreciate that. Let's say, I become disabled or something, and I become my wife becomes my guardian and goes to probate court to get all that established. I have two sisters. In normal circumstances, wouldn't their desires be taken into account if everything is established to where, even though my wife may be in charge of all of my affairs, that my sisters would have access to me to communicate with me if so desired? Couldn't that be handled in court, but based situation upon situation?
So I think, as far as in the establishment of the guardianship itself, I mean, we don't typically see those issues being hashed out because we don't know that there are going to be problems at that point. But let's take your example. You have a person who is a ward, they have a guardian, they have other family members that want to visit with those people, and they're being denied that right. If that's brought to our attention, there's any number of things I can do. We cite the guardian saying you're violating this person's right to communicate with other people. You call them into court, and if it's found to be the case, there's any number of things as a court that I can do. Finding someone's not going to be top of my list. I'm typically going to remove somebody if I think it's egregious enough that that's the case. But you can also do things like, and this is established by case law more than it is the statute, but I can also set up visitation plans. We are given very broad authority when it comes to guardianship. It's about how we manage those guardianships. So there are other remedies that we have out there. It's not just, this, that, or the other.
Thank you, Judge.
Senator Mallow?
Thank you, Madam Chair. Judge, so the process, and that's how you may handle it in your circuit, all 158 other counties may opt to do something different because you cited case law. What would codify that in statute, the practice to be in statute, to make sure that if you are a ward, and I'm a ward, and Jason's my guardian, Senator Estevez, and he decides no one can visit me, the idea that most people will say, I need to go to address this issue with probate court, where? How would that remedy occur if you were not the judge and someone else said, well, it's not statute, it's not case law, but it's not statutory?
It's statutory in the sense that if a person violates their fiduciary duties towards a ward, denying them visitation, whatever way they violate their fiduciary duty, then obviously, as the court, if I don't know that's occurring, I can't do squat about it because I don't know that it's happening. But if somebody comes to me and says, we're being denied this right, or the ward's being denied this right, it's incumbent upon me as a probate judge to cite that person. In other words, call that guardian to court and say, we need you to address these issues. And in doing so, again, I have multiple code sections that sets out the things that I can do. As far as the visitation schedule, that's not something that's specifically in the code, at least not that I'm aware of. But certainly it's established that the court has the authority to do that. But I mean, the court has remedies. I mean, it's not like the code doesn't spell out remedies. It's full of those. And as a judge, what I'm going to do is I'm going to address the criticalness of that situation with a remedy that's appropriate. If I think it's severe enough, you remove the guardian. You don't fine them. You don't pass go. You don't collect $200. You simply remove them. That's the remedy. But there's other things that you can do if you don't want to go that far. Again, I'm not at all critical of the idea that we want to protect wards. I just think that we already have those tools, and when you start putting language in there, that I don't know that it's exactly refining what we can already do.
Thank you, Madam Chair, and thank you, Judge, for being here. So I'm just trying to work through this thing, and I need your help. So what are your suggestions to help the representative's constituent? What, in that case, what specifically could this legislation do?
Again, I don't want to sound, I'm not trying to be disrespectful, because I completely understand that situation. Quite honestly, I've been doing this for 19 years. I've seen that situation. It's already there. Those things are already there in the code. The ability to, for a court to react to that situation and to address that situation, the court already has the ability to do that. So, I mean, again, when you're adding language like this, you're not assisting the court. The court already has the ability to do that.
To do what, though? Is there up to $1,000 fine? You can do that now?
The language is whatever the court thinks is appropriate. I mean, and I could I brought the code sections.
Actually, that'd be helpful.
So, I apologize.
No problem. I've been doing it myself lately.
So, for a breach of fiduciary duty by a guardian, guardian commits a breach of fiduciary duty, a ward or interested person on behalf of a ward shall have a cause of action as appropriate to recover damages, compel performance of the guardian's duties, enjoin the commission of the breach, which can be, you need to be letting these people see the ward, compel redress by payment of money or otherwise, provisions of remedy in the breach of fiduciary duty by this code section do not prevent resort to any other appropriate remedy as provided by statute or law. And that gets to the revocation, suspension, reduce or deny compensation, issue any other order as in the court's judgment is appropriate under the circumstances. Again, fines are not generally where a court's going to be in a situation like that. You're addressing the problem. Fines don't typically address problems. Fines are penalties. You address the problem by more specific actions, removal, visitation. Again, you can assess damages, but, somebody has to establish what those are.
A follow-up, if you allow, Madam Chair. What if in a case where the guardian is taking money from the ward? Like, is there reparation? Can we force them to repay that?
I can and have issued judgments against. Typically, those are conservators and not guardians.
Okay.
Guardians don't typically handle money, but there's circumstances where they can. But you have recourse. Typically, they're going to be bonded. You have recourse against the bond company. So, in other words, if a guardian is handling funds for whatever reason, they'd have to be bonded. Just like a conservator, if they handle funds, your recourse is against the bond. And you can get, repayment of that money that way.
Okay.
Senator Jackson?
Yes, thank you, Madam Chair. So thank you, Judge, for your testimony. I just want to see if I'm following your logic. But my first question is, do you have a copy of the bill?
No, I've not seen. Oh, yes.
I gave him my copy.
So I've heard from your testimony, and thank you, Senator Estevez, for our sideline conversation here to help me understand. So I've heard that you already have the capacity to issue a fine, to remove or suspend the guardianship, that those things are already present. But if you look at line 19 through 21, so is there somewhere spelled out in code where any interested party may petition the court with evidence alleging that this right has been violated? Is that already somewhere in the code?
Yes, ma'am. If you look at, code section, I'll start with 29-452, which is the revocation or suspension of guardianship. It says, upon the petition of any interested person or whatever it appears to the court that good cause may exist, the court can revoke or suspend letters or to impose sanctions. So in that case, the court would cite the guardian, appear before the court, determine what's going on, and then address it as deemed appropriate.
So in the example that the representative gave, in theory, the sister who had been denied communications could have, under current statute, brought a complaint to the probate court, and the probate court would have been authorized to intervene had they determined that that was necessary under current statute.
Yes, ma'am.
Okay. And then my follow-up question is, in your opinion, if we were to add clarifying language about the type of communications that are available, so if we go back to line 12 and 13, so if we were to say, including but not limited to visitation, telephone calls, emails that were personal email, would that help kind of address your concern about the limiting nature of having these things delineated?
Right. Yes. I mean, I think, I think I would understand communication to be any communication. If you put not, including but not limited to, certainly that broadens that. I'm not sure it's necessary, but I don't think it's, I don't necessarily have a problem with that. I just think it needs to be broader language.
Right. Okay. Thank you. So just so I can sum up what I think I'm hearing from you, you would not be opposed to language that broadens the type of communications, and in your mind, the Section 3 is just completely unnecessary in this bill, and we don't need it. Is that summing up what you're saying?
I don't think it lends anything. When you move from shall to may, it even less lends anything to the authority I already have.
Thank you.
Senator Estevez, did you have something?
Unfortunately, my colleague stole my question.
Okay, all right, good. Senator Robertson.
That was easy.
Judge Wood, I'm going to put you on the spot.
Okay.
And you've avoided the spot a couple of times during your testimony.
Okay.
Is this legislation necessary?
I don't think so.
Based on all of the power that the probate judges have when it comes to dealing with guardianships and wards and everything, do y'all already have every tool you need to resolve these types of situations?
I think so, and I mean, as a judge, I mean, the thing, it's like going out to eat. I mean, with this, I mean, instead of having this little menu, I've got a buffet in front of me, and I'm able to, pick and choose what my remedies are, and there's a fairly wide array of my buffet of remedies.
Is there anything in this legislation that you can't already do?
Not that I know of.
Thank you.
Any other questions from the committee?
Can I, I'm sorry.
Go
Can I
right
just, we can do all of these things. We don't have specific numbers, but I'm not sure that's necessary.
Spent a little time in probate court on more volatile type cases, so I just want to clarify what you're saying.
Right.
You're not limited by a number of 1,500. If you want to assess a fine of $25, $2,500, whatever, you already have that authority, and you can base that on case-by-case situations. If somebody is not allowing somebody to communicate with their family members, you can address that with sanctions that basically, I mean, not basically, it is actually a court order, and if somebody violates that order coming from you, you can take action against the individual that violates that order today.
Correct.
Okay.
And again, to speak to that, I said this already, but I'm not typically fining people. If I've got a concern where somebody's being denied a right, fining someone isn't fixing that.
Senator Estevez, you thought of something else?
I did think of something else, because I feel like I understand the representative's intent here, and I want to make sure that it's captured. So, Judge, as far as what I believe to be the intent, which is to make sure there's established right for interested parties, family members, to be able to communicate freely with the person, would adding more language about communication clarify the legislature's intent on that right for interested parties to communicate with those wards?
Well, it's spelled out specifically in the statute. that that's one of the rights that a ward has, is to communicate freely outside of the presence of the guardian with anyone they choose, with the authority of the court to limit that where appropriate. So it's already in the statute, and you know the process is already there if someone's being denied a right to communicate to for the court to address that.
Okay, Senator Merritt.
Yeah, thank you, Madam Chair. And I just wanted to clarify about the fines. I get this discretionary with the courts, if there's going to be no fine or up to 1,000, that's currently up to 1,000, if there are going to be fines.
The statute doesn't set any fine.
Okay. So, yeah, that last piece I think that we're saying is not needed, that up to 15,
Yeah, I mean, if I thought that someone needed to be fined, I've never thought that. If I thought somebody needed to be fined, I think I have the authority to do that if any number from 0 to whatever.
for whatever, it didn't even have to be limited to an amount
Right.
necessarily. Okay, thank you.
Thank you, Judge. I think we've exhausted all the questions from the committee. Representative, did you want to come and close? We're not going to vote today, but I wanted you to hear the testimony, and I'm sorry that you feel like you're in Judiciary Committee. So if you want to go ahead and make any other comments, go right ahead.
Sure, thank you. I'd like to thank the judge for coming up back to the hearing. Just want to say that we will be willing to include the word include in terms of to broaden the ways that a ward can communicate. And this language was actually given to us by a probate judge from another circuit. And I don't have the statute in front of me, but we did do some research, and the fines are limited. And I don't have the reference right now, but I'd be more than happy to, when I get it, to send it back to the committee, exactly where it says there is a dollar amount for the fines, and which is why we increased it up to $1,500 in this bill. And the bill does not require any circuit to follow this legislation. It's an option.
Okay, well, I don't see any other questions, so thank you very much for your presentation, and we're adjourned.